Hey, how you doing, Jalen? We're doing a live legal tea, and I think it's the perfect opportunity to explain international trademarks and fraudulent applications again, and just what you can do when you're getting ready to make big moves. And you guys, this evening, so I have on my Own Your Genius t-shirt and some sweats. So it is what it is. But I'm so glad that you are joining me live this evening. Listen, so what was it? While I'm going live, what was it about? It was earlier this week, last week, that they went live, or they made Prince Henry and Duchess Meghan made the announcement that they were leaving. They were leaving, and they didn't really want to be a part of the royal family. He was leaving his inheritance and the money behind. And they want to split their time between the U.S. and the U.K. so that they can pursue their own ventures. And the main reason, we know why they're doing it. Um, Harry, I said Henry, but Harry really didn't want the same thing that happened to his mom to happen to his wife and his child. You know, she was hounded by the media relentlessly, and you can see that trend and that pattern. The same thing happening with Meghan, and he was just like, I'm not going through that again. Like, we're not going to do it. It's not even worth it. So for that reason, that's why they decided to split their time. Before they got ready to move, so here's the tea. Before they got ready to move, they filed what I saw was like hundreds of applications. That's what the media is saying. Hundreds of applications, trademark applications in the UK to protect their interests, because what they plan on doing or what they want to do is somewhat move in the direction of the Obamas and other past presidents, where they are really making a media presence, have a huge media presence, and really monetizing their brand. They want looking for book deals, assuming book deals, media production shows. I heard that Megan just became the voice of a Disney character, so that's good. But what you also want to keep in mind is that they filed an application from everything from like pencils. Like, they didn't just do one category. They filed several different categories in the UK. In the UK, where they are from. So we're going to talk about that and why that is a. And some people are like, well, why would they do that? They're not the first people to file trademarks in that status. The Obamas, they filed an application. They have two applications pending. They have one for HGP, and then they have another one for HGP. I'm sorry, for Higher Ground Productions. So HGP stands for Higher Ground Productions. So they have an application. If you guys remember, about a couple of months ago, I actually talked about the Obamas and their trademark situation, where they got an office action saying that there was a conflicting application, meaning that someone already had a registration for something similar. It wasn't the exact same thing. The Obamas wanted to trademark Higher Ground Productions, and there was already a trademark for Higher Ground Enterprises. They were both in the media realm. And so what the Obamas did, which some people didn't like, they filed to cancel the prior registered trademark on the grounds of fraud. Essentially, what they're saying is, when they filed their application, when the person filed their application, their use state was not an actual in use state. And we're going to talk about that when we talk about this application. We'll talk about it now. So what that means is, with the trademark application, you have two applications. You have an in-use application and you have an intent to use application. What you are saying when you file that in-use application is that you are using that mark in commerce associated with goods and services right now, right when you file that application. If you are not, let's say you file the application on January 14th, 2020, but you don't start selling goods until January 15th, 2020. Guess what? Your application was fraudulently filed. Because why? You're not selling goods. You were not selling goods on January 14th, 2020. When your application is fraudulently filed, in that sense, it's void. So they moved to cancel that trademark application, saying that they had their dates wrong. Well, when I was preparing for this, I saw that as of December 30th, they filed a second extension of time request to have the proceedings suspended because they're working out a negotiation. So, but Prince Harry and Duchess Meghan, they are following suit. They want to make sure that their brand is protected moving forward, which is a very, very smart deal. They probably want to, like I said, mirror their efforts in the path of book deals and TV shows. The Obamas have a multi-million dollar deal with Netflix. So that's what some people are saying that they're looking to do. Well, let me just tell you, after hearing about them leaving and seeing all the applications that were filed in UK, a California lawyer took it upon himself to file a trademark in the United States for, let's see, Sussex Royal, which is who they are, right? And that's what their trademarks in the UK are for. He's filed it for communications by computer terminal, transmissions of video, audio, and data via the internet. So he filed a trademark for somebody else's brand in the U.S. On the premises that he was just showing them. He was what does he say? Showing them a lesson. Showing them a lesson that they shouldn't overlook such important matters. He filed a 1B application which says that I'm not using it in commerce now, but I have a bona fide intent to use it in commerce in the future. It's so many things wrong. Like, where do we start? Where do we start? You have a 1B application, which says you're going to have a bona fide intent. Okay, I'm not going to be sad anymore. But so you have a 1B application was filed by someone who has given an interview to TMZ. TMZ saying that he had no intentions of using it with goods or services. That he just filed it to show them, to give them a lesson, to show them a lesson, right? Who does that? Only people who don't know any better do things of that nature. Because people who know better know that that's fraud, and there are consequences to fraudulent applications, right? So, where do we start? Let's start with the fraud. How about we start with the fraud, right? So, we're going to start with this fraudulent application. So, what is a fraudulent application? It is, according to USPTO, a fraudulent application is getting a trademark registration. Well, let's see. How should I say it? Knowingly making a false statement, so telling a lie on a statement, or making a material misrepresentation, meaning that maybe it's not a whole lie, but you stretch the truth on something that was really important relating to this application in order to get the application approved. So let's back up. So he filed a 1B application. What he told us a lie about, or the material representation or false statement, was that he had a bona fide intent to use the trademark in commerce. Like, that's the whole part. Like, that's the crux of the application there. Like I said, there are two applications. You have your 1A application and you have your 1B application. Your 1A application says you're using it in commerce right now in association with goods or services. Because trademarks, some people are new to my live, and for those of you guys who are new, hey, welcome. I'm brand attorney LaConya Murray. I'm the owner of Off the Mark IP Solutions. You are catching a live version of The Legal Tea, which is my weekly podcast where I talk about pop culture from a legal view. So not your average tea that we're spilling over here. So listen, trademarks, for those of you guys who are new, trademarks protect brand identifiers. Those brand identifiers are those things that help consumers identify the source of a good or a service. The source of a good or a service. So in order for something to identify, it has to actually be available. So that's an in-use application. So, a few years ago, a few decades ago, they created what's called an intent to use application. That intent to use application says, hey, you know what? I'm not using this in commerce right now, but I plan on doing it. Like, I got some things in the work. I'm preparing to launch. I got a business starting. I'm getting everything together so that I can launch soon. I have a bona fide intent to use this trademark in association with goods or services. A bona fide intent, which means a real intent to use it in commerce. So that's what you're saying when you fill out that 1B application. You are saying that you plan on using this in commerce. So that's material. If you don't plan on using it in commerce, you can't get you can't get a trademark. So the only way to get that 1B intent to use application is to say that you have an intent to use it. So that's material. Like if he would have put on the application, you know what? I don't plan on using this in commerce. I just want to show them a lesson. Application would have been denied. And to be clear, the application was just filed January 8th. So it hasn't been approved. It hasn't even been looked at by the USPTO because once it's filed, it sits in the database for 3 months until it's assigned to an examining attorney. The only way that they will look at it quicker if there are letters of protest filed, meaning objections from the public why it shouldn't be filed, why it shouldn't be approved. So that's what we are right now. We're talking about this supposedly fraudulent application that was filed. In my opinion, it does qualify for a fraudulent application because, as USPTO says, you have a fraudulent application if the applicant knowingly makes a false or material representation of the facts in connection with the trademark application. And saying that you have an application that is going to be in commerce when you know good and well that it's not is a material fact. Listen, trademarks are not like domains. Sometimes I have an idea for a business and I go and I buy the domain name until I figure out what I'm going to do. And I can do that. I can just buy a domain name and sit on it until I determine and figure out what I'm going to do. Trademarks are not like that. You can't just you can't just register a trademark and be like, nope, I'm not going to do anything. Like, I'm just going to sit on this. I'm going to get it in case I do something with it. When you file that trademark application, you're not saying I might do something with it. You're saying I am either doing something with it or plan on doing something with it. There's no maybe in the mix. There's no maybe in the mix. So domains are not like that. And I'm not talking about cyber squatting. People cyber squat domains, and cyber squatting is when people take celebrity, they take brand names or really popular celebrity names and things connected with them, and they buy the domains hoping to sell it to the brand, to the company or the celebrity at a really high price. That's cyber squatting. So I'm not talking about cyber squatting because you can't cyber squat, but you can buy a domain if you buy it in with the intentions of, hey, maybe I might use this in the future. You can buy domains for that purposes. The applications are filed. When you file an application, you are filing it really under the perjury of law. Like you sign it saying that everything is truthful, that you, to your best knowledge, everything is truthful. You didn't lie, no misrepresentations. So if they come to find out that you actually got this application by false means, the person that did it, the applicant, can be liable by civil action. So essentially, Prince Harry, Duchess Meghan, they can sue him for any damages that they sustained because of his actions. And in some situations, not all situations, and really not that common, you can be sued, have other civil and criminal penalties for that. So that's number one. This application that was filed just for the heck of it, just to show give somebody a lesson, I believe that it was fraudulently filed. In my opinion, it was filed fraudulently because the guy he gave an interview like, you are an attorney. They say that the articles keep saying he's a trademark attorney. I just really can't imagine a trademark attorney doing that. And if you go in the database, you can see where he has filed a few applications. But you don't file trademark applications just for the heck of it. Like, you don't. Jocelyn says, since he said publicly that he has no intention to use it, would that automatically squash the application, or is that even considered? It depends. It depends if the examining attorney, if they know that, if they are aware of that, then yes, they can use it. It can also be used against him in cancellation proceedings or in opposition of proceedings. And so what I mean by that is this. If, let's say, USPTO examining attorney has no idea that he fraudulently filed this application and they approve it, when they approve it, they are approving it for publication. What happens in publication is that the public now has 30 days to object to the registration. So even though USPTO says that it's good, it still gives the public an opportunity to object. And those people have to have a trademark or something that will be harmed by this registration. So a great example, uh, and in those proceedings, those parties have to prove whatever it is that they're claiming. And a great example of that, a great example, Jocelyn, of something said in the media coming back to be used against them is the Blue Ivy Carter trademark. You know, Jay-Z and Beyonce have been trying to get this Blue Ivy Carter trademark for years, since the baby has been born, right? When I was going through some of their proceedings, Jay-Z did an interview to Vogue, and he said he said they trademarked Blue Ivy's name just so that no one else would try to capitalize off of it, because he knows that people are. And so that's saying that he had no intent. Matter of fact, I think he even said, like, we don't plan on using it. We just want to make sure that no one else can. So that's very similar to what this attorney did, right? And so those words came back in the proceedings. When they filed the objection, one of the reasons they object to the filing of the application was fraud, and they put that in there. They put the article in there that this is what was said. Like, they have no real intent to use this, so they used that in the application, and they said that in their opposition paperwork. So yes, it can actually be used against you. So that's why, like, you don't say stuff like that, and you especially don't do it to TMZ unless you are looking to come up. I mean, TMZ is a pretty big media outlet, right? And if you want people to start Googling your name, if you want people to know who you are, then you do something like this, and now everybody knows your name. My Cheers voice, right? Everybody knows your name. So that's challenge number one, right? Challenge number one is this application seemingly was filed under fraudulent pretenses. Number two, the challenge number two is he claims that he filed it to teach them a lesson, right? Mind you, before he filed this application, there was already news articles going out that they filed hundreds of applications in the UK. And about a week before he filed his application, they actually filed an application with WIPO. WPIO. Hold on. Is that right? Did I get my initials right? No, I got them backwards. WIPO, World Intellectual Property Organization. And what that is, it's where a lot of countries come together and they basically say, hey, if they file an application here, it can be the basis of an application there. So for our U.S.-based businesses, if you file an application here in the United States and you want to do business internationally in another country, not all the countries, but you had wherever you plan on doing business at, then your United States-based trademark application can be the basis of your application in other places through WIPO. Like, that's just something that you have to consider. So no, you don't see that application in the U.S. database right now, but the fact that they have it filed in the U.K. and they just filed it, like, that can be basis for the U.S. trademark application. So it's not necessarily that they didn't file it in the trademark application. They don't need to file it automatically in the U.S. if they filed it in the U.K. Like, you don't have to do that. So it wouldn't really. Now I'm trying to figure out who's schooling who, right? Who's getting the lesson? Like, and we're going to see how this plays out, especially since he says that he said he was just doing it to show a lesson, and he doesn't plan on charging them for it. Like he said, I'll give it to them, But essentially, what I assume that they'll do is have him cancel the application, and them just move forward and registering it in the classes that they need to register it on their own. And like I said, they have a slew of things that they want to register their trademark for. I just really wanted to talk about that and answer your questions and just make sure that you know that when it comes to international trademarks, so let's talk about international trademarks for a moment. A lot of people say, well, can I just file one application and be protected everywhere? And that's not how that works. Just like in the US, like your mark has to be in use. Not only here in the US, right? So your US based trademarks protects you, gives you the right to exclude other people in the United States from using the same or related trademark in the same or related field. So that means that you file a trademark for something, it doesn't give you blanket protection over everything and everybody. Meaning that if I file a trademark for something under the law, right, that's law related, I can't stop someone that's in the automobile business from using that same or similar mark because it's not related. And the reason that is because trademarks, the purpose of trademarks, the reason brand identifiers are important is to help consumers make readily, so that consumers can readily identify the source of a good or service. It's all about protecting the consumers so that what they intend to buy, they actually buy. What they want to spend their money on, that's what they're spending their money on. Because we make decisions, sometimes we make them quick, sometimes we take a little bit longer, but we have different things, different processes that we go through in order to spend money, whether it's a referral, whether it's past experience, based on marketing positions. There's different things that we take into considerations before we spend our money, right? And so when we do finally decide to spend our money, we want to make sure that what we spend our money for on is what we intended to. And the thing that just came into mind, on Facebook and Instagram, they have all these sites that are selling clothes, right? They're selling these clothes and they look so good. And then next thing you know, you see someone said, "Oh, I just ordered this off of a site, and this is what it's supposed to look like." But then what they got has like 3 arms, and it's just not the same. So you want to make sure what you're spending your money on is what you intend to spend your money on. That's why trademarks are so important. So in the United States, you have to give you the right to exclude other people using the same or similar mark in the same or related field. And that same thing holds true in other countries. You have to be selling that good or service in that country in order to get that protection. And it's not just all international, like whatever country you plan on using that mark, that's where you need to make sure that you're protected. Did you find this information valuable? Let me know. Do me a favor. This is how you can let me know. Subscribe to the Legal Tea. Go to your favorite platform and hit the subscribe button. And then after you hit the subscribe button, hit the notification button. And then after you hit the notification button, leave a review. Give me some feedback. Let me know what you really got out of these episodes and what you like most about the Legal Tea. I would love to work with you in 2020. If you're ready to start riding dirty in your business, meaning that you don't have contracts, trademarks, copyrights, you haven't taken care of any of those things, give me a call. I'd love to help you. Go to LaConyaMurray.com to schedule your consultation. I look forward to speaking with you, and until then, keep growing your business and building your brand. Take care.